Hi and welcome to everyone who has joined this Phil Fisher webinar today. Thank you so much for joining us and taking the time to listen. We're really glad you could join us. I am one of your hosts today, Felicity Fisher, a partner in the privacy team based out here in our Silicon Valley office. And I'm joined by my brilliant colleague and co-host, Paul Lanois, who is a director based out here with me in sunny-ish California. Before we get into today's topic, I just wanted to let you all know that if you are enjoying these Phil Fisher webinars, which we're delighted that people are enjoying them, the good news is that others are available to download and listen to on the Phil Fisher Silicon Valley YouTube channel. And actually, in addition to the webinar series, we've also started podcasting, which we're really excited about. And you can actually subscribe to the Phil Fisher podcast in all the usual places. So if you want some privacy chat on your way to work, they are usually not more than 20 minutes, and kind of we're aiming to cover some, important topics as they come out more in sort of real time on those podcasts. We've got a lot to cover today, so we probably won't get time to address your questions during the webinar, but please do send them our way via the comments section in the webinar, and we'll follow up with you afterwards. Okay, so to today's programme. I can hardly believe this, but it's 18 months since the GDPR came into effect, and since then we've almost entered a new era of privacy, celebrated yesterday with International Data Privacy Day. And I think we can all agree that the GDPR has set the standard for privacy compliance, thrusting data and privacy issues firmly in the global spotlight and setting off a global trend in other jurisdictions, including the US, which won't have escaped everybody on this webinar, the CCPA coming into effect this month, and other states like Washington expected to follow suit this year. With customers demanding more of their vendors, individuals starting to flex the new privacy rights that they've got, and breach notifications on the rise, as well as what seems to be a kind of weekly proliferation of global privacy laws and regulations. Frankly, we're all struggling to keep up. And I see many of our clients facing the challenge of trying to work out where best to focus their resources and time with so much to do. So we thought we'd put together this webinar to kind of provide our predictions for what we think 2020 is going to look like from a privacy perspective, and also kind of give you guys some practical guidance on what we think are some of the key compliance actions to keep top of your to-do list for 2020. You can't do it all, so what are the things we think should be the key focus for many companies this year? But before we dig into that, I thought it would be helpful to kind of look and cast our eyes back to 2019, just to have, provide some context to why we've kind of put together this particular list. So 2019 saw the European regulators starting to flex their enforcement powers, and according to statistics that I've seen, I think there were roughly 150 enforcement actions taken in 2019. But I think we were relatively surprised to see that there wasn't the level of enforcement action that many had feared in the run-up to the GDPR. And I think the total value of the fines issued came to something around $126 million. And with most of that being taken up by this fine issued by the CNIL against Google for its lack of transparency and a lack of valid consent in relation to its sort of personalisation of ads. The ICO, the UK regulator, also grabbed the headlines by issuing an intention to fine Marriott, a jaw-dropping $130 million, and British Airways to around $240 million in connection with the sort of widely reported data breaches that I'm sure everybody heard about last year. In fact, these fines were expected this month, but an extension has been agreed, and now we're sort of expecting final enforcement notices of those in March this year. So those fines that we heard in the headlines were just an intention from the ICO to issue those fines. We'll find out in March what the reality of those fines and the penalties that will be issued by the ICO. There were also other noteworthy fines issued by the Austrian and German regulators, but none reaching the lofty heights of 4% of the global turnover, which we all kind of feared. But as we say in California in relation to the earthquakes, we know the big one is coming. And so I think that we just wanted to remind everyone that, you know, although we didn't see the crazy levels of enforcement that many had feared in the run-up to the GDPR, I think we can expect that 2020 is going to be a year where we see much more active enforcement. The Irish regulator alone has 21 open investigations against some of the Valley's or Silicon Valley's largest tech companies like Twitter and WhatsApp. And it's also kind of actively probing into the practices of Google and other ad tech companies following various formal complaints. We're also approaching the 2-year anniversary of the GDPR, and in fact the European Commission is tasked with conducting a review of the GDPR before the 25th of May this year. And in the run-up to this, we've already seen national governments, you know, providing feedback to the European Executive Board that they support increased cooperation between competition, consumer and data protection authorities in the supervision of big tech companies. And so that is, you know, likely going to fuel more active enforcement across the EU this year. And it's also expected that the regulators will move away from sort of trying to focus their energies on guidance. We know there's more guidance to come this year, but I think we're going to see them channeling more of their available resources into, you know, addressing and more proactively enforcing this year. And I think we're going to see enforcement beyond just kind of reacting to data breaches, but to other areas of non-compliance with the GDPR. And I think it's interesting to see that the Berlin Data Protection Authority recently issued a 14.5 million euro fine on a real estate company for over, you know, their retention practices. So it's not just, you know, data breaches or data subject complaints that are going to get you in trouble. We can't do any, being British, we can't do any webinar or podcast or panel without having a little reference to the dreaded Brexit. And I thought you guys might be interested to know or get an update on what's happening with that. So with great sadness, with great personal sadness, I know we're not supposed to talk about politics on this webinar, but I am pretty sad that we are going to be officially leaving the European Union at the end of this month on the 31st of January. The relatively, or I suppose all things being relative, the good news is that the UK government managed to negotiate an 11-month transition period. And so that effectively means that we've got until the 31st of December for the government to try and work with Europe to agree what happens, what our relationship with them looks like after the transition period. But during that time, we're effectively maintaining the status quo. And so to some extent, that means that people don't need to make any immediate changes to their privacy compliance, but they should be aware that at the end of this year, depending on what is agreed with Europe, including whether or not we manage to get an adequacy decision, we may, you know, companies should just keep track of those developments and be ready to adjust their compliance as necessary as we kind of see what is happening with those negotiations through the course of the year. Finally, another area that I think is interesting to monitor in 2020 is how the privacy legislation is going to be impacted by the new incoming president of the European Commission. So we've got a new president, and one of the pledges of the new regime is to propose new legislation that will deal with artificial intelligence. I think there's already been a leaked document which indicates that there might be sort of sector-specific approaches and other things, but we're basically waiting to see the impact of this in terms of the processing of personal data via artificial intelligence technologies. And I think that's something that's going to inevitably become a key discussion point in 2020. So those are sort of top predictions in terms of you know, legislative changes, but we thought we'd now sort of dive into what are the top 5 issues to prioritise this year. And I promise Paula's going to get a chance to talk in a second. So the first thing that we wanted to, sorry, I've been told off for rustling too much paper, sorry. The first thing that we wanted to sort of flag is that I think the GDPR kind of has inspired not only the CCPA, arguably the CCPA was inspired by both GDPR and Cambridge Analytica, but we've also seen a kind of proliferation in other countries starting to implement GDPR-like privacy legislation around the world. So we know the CCPA entered into force in January this year, and there are also talks about, or there's also the prospect of CCPA version 2.0, which is the Californian Privacy Rights and Enforcement Act. And if that is passed this year, that should come into effect in January 2021. And while the CCPA is very much focused on the disclosure of personal information, version 2.0 potentially contains more restrictions on the actual use of data, particularly sensitive data. And other current proposals, I was kind of interested to see that there is a much wider definition of sensitive data to include things like the contents of private communications, precise geolocation data, and account login details. So everybody should sort of keep track of that CCPA version 2.0 to see where that lands. And then other states in the US haven't been idle either. So we've got Washington State, but you know, it's got its own privacy data protection law on the books, which looks very much like the CCPA, as well as the New York SHIELD Act, which significantly amends the New York breach and data protection requirements. And that's due to go online in March this year. So it looks like the CCPA and the GDPR have not set the kind of ceiling for privacy compliance requirements, but they've effectively set the floor. And I think, you know, moving forward, we're going to see many other countries around the world introducing very similar privacy legislation, which will at their core have very similar principles to that which is reflected in the GDPR. And you know, it's noteworthy that South Korea is currently updating its regulations, and I think their goal is to try and achieve adequacy in the coming year. We've also got Brazil's first general data protection law, which will come into force on the 15th of August this year. And like the GDPR, it's a kind of omnibus law covering many principles of data protection that you're familiar with, having dealt with the GDPR.
If I may as well, there are other countries as well, like Hong Kong as well, you know, looking into their own privacy laws to see if they should update those laws. In the US as well, there are a number of states. You mentioned Washington, but there is also Virginia, New Hampshire, and so forth. And you know, because there are more and more US states as well, you know, looking into amending their privacy laws, there has been, you know, a growing call as well, you know, to have a federal privacy law, a law, you know, which would, you know, be applicable throughout the different states, as opposed to having a state-based approach. Because obviously, well, when you have so many different privacy laws in each different state, each, you know, with their own different interpretation, sorry, their own different definition, different thresholds and so forth, it's going to be increasingly difficult for organizations as well to comply with the different laws, because especially smaller organizations are going to find it extremely challenging to keep track of all those different laws and to comply with each of them as well.
Yeah, and I think the IAPP conducted a study and found that 43% of organisations were working to comply with 5 different privacy laws. And the same study said that 56% of respondents were working towards a single global privacy strategy tailored to individual jurisdictions' requirements where required. And I think that that absolutely makes sense, because companies are starting to realise that a single strategy built on kind of strong privacy principles is going to be much more effective moving forward. And you know, many people sort of took the Europe versus the rest of the world approach. They might have had a privacy compliance regime for Europe and then taken a slightly more lenient approach for some of their compliance in some of the rest of the world. And I think, given that you know, various aspects of the GDPR are now being replicated globally in other countries' laws, I think it's far too simplistic to sort of say we're just going to have one approach for Europe and something else for the rest of the world. I think that it makes sense for companies to start looking into a united sort of enterprise-wide strategy. And you know, organizations like NIST and ISO have recently updated their data privacy compliance frameworks. And you know, some of these are quite helpful as they incorporate some data privacy best practices and common regulatory requirements to help companies kind of frame a more global approach. And in particular, I noticed that the National Institute of Standards and Technology, so NIST, has just issued a new privacy framework, which was published on the 16th of January, so this month. And it kind of follows a similar framework to their existing cybersecurity infrastructure framework, but it's sort of meant to sit alongside it and help companies come up with a much more kind of holistic approach to doing things like, you know, implementing accountability, privacy by design, all those kinds of things, and generally to help people put in place a sort of global approach to privacy. So worth having a look at the framework that's been published by NIST. I think it's potentially a kind of helpful way to think about framing your global compliance strategy. I think we're on to the next. Oh, sorry, that's me. I'm doing the next one as well. Got to hear my voice for a little bit longer. So accountability. Accountability is a principle that is pretty core to the GDPR. Now we're starting to see it as a principle, as I mentioned before, embedded in other privacy laws that are coming into effect around the world. And the reason that we flag this as an important thing to not lose sight of for 2020 is that it's you know, a number of regulators, including the ICO, have stressed the importance of not forgetting about your accountability obligations. In fact, the ICO in its regulatory action policy kind of stated that, and I'm quoting here, our hierarchy and risk-based approach means that it's more likely that penalty will be imposed where, for example, there has been a failure to implement the accountability provisions of the GDPR. And, you know, we've in various speeches from the Information Commissioner, they keep making reference to this concept of accountability, and they've even launched a survey encouraging feedback on their plans to produce an accountability toolkit that controllers can use to help develop their accountability framework. So it's not something to lose sight of, because key to being able to address your accountability obligations is to be able to demonstrate your compliance, you know, be able to present evidence of the steps that you've taken to create a culture and commitment to data protection within your organization. And that's important because, you know, if you are ever the subject of a regulatory investigation, or even just to be able to respond to customer questions, you need to be able to show an evidence that you've met and continue to meet all of your obligations under the GDPR. And so, and unfortunately, that's not necessarily an overnight task, because it's not, accountability isn't a box ticking exercise. It's a living and breathing obligation. And so you constantly have to be going and looking at what you're doing and checking that you're able to continue to evidence compliance with the principles of the GDPR. And on this slide, we sort of picked out some of the key accountability requirements that we think you should not forget in 2020. So, you know, there's been a number of webinars and sessions that I've been to on data privacy impact assessments. In fact, we've previously done our own webinar on this, and my colleagues have done a fantastic blog on this, which they published last week, which everybody should go and check out, because it provides a little bit more information about what you need to think about when you're doing a privacy impact assessment. But it, you know, it's essentially a requirement of the GDPR that you do a DPIA in certain circumstances where you're doing high risk processing. And so that would be the case, you know, if you're processing sensitive data, information about children or other vulnerable adults, or if you're doing profiling that has a significant or kind of a significant effect on individuals. So we're talking about more of the kind of creepier end of your processing activities. You should be doing a DPIA to make sure that you've mapped out and thought about how you can comply with the principles of the GDPR when you're doing that type of processing. And in addition, we've also got the local data protection authorities have got the power to issue so-called DPIA blacklists. And these are lists that the authorities of various member states are required to publish under the GDPR, which set out when DPIA is required. So if you're thinking about trying to understand when you need to do a DPIA, you need to look at the GDPR, you need to look at the European Data Protection Board's guidance, and you also need to look at the blacklists that have been issued, because they will collectively tell you when you should be thinking about doing a DPIA. And again, I'd refer you to the brilliant article and blog post from my colleague Richard and others, because they've kind of helpfully set out what the blacklists say and when you should be doing it. But essentially, you need to find a way to embed a process within your organization that enables you to kind of catch when new processing activities or new technologies that you're working on might actually involve additional data collection or high-risk processing. And so it's really important to make sure that you've thought about this, because again, if a regulator comes knocking, they may want to see a copy of your DPIA. So you should be ready with that kind of documentation behind the scenes. So think about your current processing activities, identify the ones which you think are high risk, and then work towards kind of implementing and focusing on undertaking those DPIAs. The other thing that I think is worth keeping top of mind is conducting legitimate interest assessment. So everybody is really keen to kind of rely on their legitimate interests as their kind of lawful basis for processing personal data under the GDPR. But it's not a kind of cure-all, easy ground to necessarily rely on, because it does require you to actively think about and explain your purpose and justify why your legitimate interests do not outweigh, or you at least be able to demonstrate that your legitimate interests do not negatively impact the individual's rights and freedoms. And you've also got to be able to demonstrate the necessity of the processing. And the best way to do all of that kind of assessment is to document your legitimate interest in what we call a legitimate interest assessment. And that can form part of your DPIA, or it can be a separate document. But again, really important to kind of work out where your key processing activities rely on your legitimate interests to try and get those LIAs done, because you can have them in your bank of accountability documents and be ready to show them to a regulator if there's ever a kind of review of your data processing activities or a question over whether or not you do in fact have a legitimate interest. The other thing we wanted to flag is that everybody in the sort of run up to the GDPR was frantically doing data mapping exercises and creating data processing records to comply with their Article 30 obligations. But I think a lot of those maps and records haven't ever been revisited in the last 18 months, and that seems to be the case with many of my clients. So just a reminder that you should be going back and updating those maps and records to make sure they continue to accurately reflect the nature of your data processing activities. Just sort of many people were sort of relying also on a kind of manual process to do that. You might want to think about moving towards relying on a kind of technology provider out there to help you maintain your records. So I think it's probably a much more efficient long-term strategy for keeping on top of that accountability obligation. Paul, I think you're going to talk a little bit about training and some of the things that they might need to think about from a CCPA perspective on that one.
Thank you. And yes, going to the next slide, I'm going to talk now about security and breach reporting processes. And of course, this involves, what do we expect to be the main threats in terms of security for 2020? And the first prediction, I would say, for 2020 from a security perspective would be that we expect phishing and other social engineering scams to become even more sophisticated, targeted, and believable. In 2019, business email compromises was one of the most common threats to businesses. And these types of attacks usually require criminals to impersonate their victim's boss, colleague, or friend over email and convince the victim into sending money, gift cards, or sharing credential information. And for those types of attacks to be effective, they need to be tailored to each individual victim, which makes them somewhat difficult to put into place. But because these are profitable, those attacks are on the rise, and they are profitable because people have become more wary of traditional scam emails. According to the US FBI, such scams have already caused over $26 billion in losses in the past 3 years. So we expect these types of scams to continue and to be used more and more. Ransomware attacks as well are expected to become more targeted and even more common than they are nowadays. And progressively, attackers are interested in targeted attacks. They are going against businesses that they believe are vulnerable and businesses who cannot function without any downtime. And this includes healthcare organizations, industrial control systems, and other types of sensitive organizations. And that's why you have the term disruptionware, which is becoming more and more used now in the security field, because this refers to a new emerging category of malware, which is designed to suspend operations within a victim organization through the compromise of availability, integrity, and confidentiality of the systems. And disruptionware deviates from, I'm hesitating to use the word traditional here, but it deviates from ransomware attacks, because the goal here is not only to encrypt and deny users access to the data, but here the goal is to disrupt operations and production, and therefore, companies in the manufacturing area, in the industrial area, infrastructure as well, they are becoming bigger targets. And these types of attacks are becoming more and more widespread, in addition to the more classic ransomware attacks. And in fact, at the end of 2019, the US FBI issued an announcement regarding the increase in the number of high-impact ransomware attacks against private and public US organizations. In addition, you have as well an increase in the number of attacks against the cloud, because you have, of course, more and more organizations moving their servers and the data to the cloud, and that's why there is more value for attackers to go after the cloud and the assets which are based in the cloud. This is not to say, of course, that you should not use the cloud. I'm not saying that at all. I'm just saying that because people are putting more and more data into the cloud, it's becoming more attractive, and attackers, they always go where they believe there is more data and more value for them to attack. The cloud can be secured, of course, but it requires work, and this means that you need to ensure that your organization is focused not only on security of local systems and local data, but that resources are allocated as well, to secure cloud-based assets. In addition, as people are working more and more remotely, you have the use of mobile devices, which is on the rise over the past few years. You have to ensure as well that those devices are protected. Having said all that, cybersecurity is not all doom and gloom, because there are a number of steps that you can take to respond to those different types of attacks. And data protection laws such as the GDPR and the CCPA have required organizations to demonstrate that they have implemented appropriate technical and organizational measures to protect their systems and their data. So you have to make sure that you have a plan to respond to attacks. Do you have a plan in place? Do you know what to do if such an attack takes place? For example, do you have clear designations of responsible individuals that you should contact? Do you have a procedure in place to contact law enforcement, other authorities? Do you have a good understanding of what your data is? Do you understand as well the importance of the data in your overall business plan? Those are all topics that you should be considering in relation to your response plan. Of course, you also need to make sure that you have a current and workable disaster recovery plan to make sure that your organization is able to get back up and running if there is a cyber attack. The backup of data is important as well, because if you suffer a ransomware or disruptionware attack, then you need to be able to resume business operations as quickly as possible. Make sure as well that you have conducted third-party risk assessments before you engage with third-party vendors. Security is only as strong as the weakest link in the security chain, right? So you have to make sure that the vendors that you engage have good security measures in place. Ensure that your security controls are working, that they're up to date. It's not good enough if you have done something 2 years ago. You need to make sure that it is still valid for what your organization is doing right now. Regularly test as well your incident response and your breach reporting steps, because the faster response time that you have to attacks and incidents means that you reduce the damage to your organization.
Yeah, and I'd just add to that just a reminder that the GDPR and the CCPA both require that a risk-based approach to security, and you're sort of, when we talk about appropriate security, which is something that both regimes require, it's really appropriate given the nature of the data and the risks to the organization. And so what that in practice means is that for you to be able to really demonstrate that your security measures are appropriate, you should have done some kind of risk assessment and documented, and have that again, and it sort of again goes to accountability, but have that in your bank of documents to sort of cover yourself there, to demonstrate that you've really thought about whether or not and tested whether or not your measures are appropriate. And again, looking to the NIST and ISO standards can be helpful there to sort of framing some of that security compliance. And you can't underestimate the importance of that third-party risk assessment, security risk assessment. Everybody's very focused on getting those DPAs done, but in the background, your information security team should be vetting your vendors to check that they are able to offer appropriate security measures. Because as a controller, that is a key part of your compliance obligation when you're going out and procuring vendors, is to check that they can actually offer appropriate security measures.
Moving on to the next slide now, data subject requests, probably one of the biggest risks, I would say, exposures for companies, and that's why it's something that you definitely have to look into. And it goes without saying, of course, that if your organization is subject to the GDPR, then you need to already have in place a process to handle data subject requests within the time frame imposed by the GDPR, the 1 month limit. You should bear in mind as well that the calculation of the 1 month limit should begin from the date on which the request was received, not the day after. So for example, if a request is received on February the 3rd, then the deadline for responding would be the 3rd of March and not the 4th of March. So this is something that you should bear in mind, because a lot of people have fallen into the trap to believe that it's the day after.
And I just to add some further context of why we've added this to the slides, sorry, Paul. We saw the sort of weaponization of data subject requests in 2019. So a number of our clients there were a few clients that actually, had relatively few data subject requests, but those who did were in many cases quite deluged with requests, and some of their processes that they had put in place quickly became sort of fell apart really under the volume of requests. And so we're really encouraging people to take another look at their data subject request flow and just make sure and sort of think about, well, how many requests did we receive last year? Is our current process fit for purpose, and can we really respond effectively to requests given the volumes that we're receiving? And we stress this because actually where you're likely to fall down and be, invite regulatory scrutiny is if a disgruntled data subject doesn't receive an effective response to their request and then goes and makes a complaint to the regulator. So getting that process and that interface with the data subject right is really important. And also just to remind you that whatever process you have in place should not be overly onerous on the data subject. So I've seen people going to great lengths to do things like verify the data subject's identity with all sorts of, you've probably seen the selfies that people now need to take for some of these when relying on some of these third-party verification processes. I think that's good, and it's important to make sure that you do not, for example, send data to the wrong data subject. So if you have reasonable doubts, which is what the law requires, reasonable doubts about an individual's identity, then you should, and it's very important to do this, be taking steps to verify their identity, but you should not be introducing processes that are overly onerous, and ideally you shouldn't be asking for more information to verify someone's identity than you have on your systems already. So just thinking about making that an effective user-friendly experience, and checking that as a business you can actually manage those requests, and making sure that your employees within the organization know how to recognize those requests. Because another issue that I spotted was that requests were coming in but they weren't being managed properly because somebody at the other end of the privacy at .com alias was not properly monitoring the inboxes. So really just checking in on your process, and as Paul's about to describe, also making sure that you update those processes to reflect the requirements of the CCPA, which are effectively the same but slightly different as the GDPR, and so you need to just make sure you're tweaking it. And Paul I'll let you pick up that conversation.
Thank you very much. So this brings me exactly to what I wanted to say, that even though you already have a process in place, because you are subject to the GDPR and therefore you have already implemented a process to handle data subject requests, you have to bear in mind that you can of course leverage that process that you have in place now, but then you still have to make certain tweaks to it because the CCPA is slightly different from the GDPR. For example, the CCPA will require you to identify the data which is that you collect. Does it include the sale of information? And if that's the case, well, you will need to be able to disclose that. There are certain categories of information which are excluded as well by the CCPA. For example, information which is covered by HIPAA, the FCRA, any other state or federal law which would be exempted from the CCPA scope should be considered as well, because you should not be disclosing that information. And another big point to bear in mind as well is that whereas the GDPR doesn't impose any time limit in regards to the when you have the data, any time limit as to when the data was collected in relation to the CCPA, however, you would only need to disclose information within the past 12 months, and information which was collected more than 12 months ago would be exempt from disclosure under the CCPA. So this means that the information that you would provide would likely be much less under the CCPA than under the GDPR.
Yeah, and sorry, we're hurtling towards the end, and I promise we'll finish in the next 5 minutes. But the final sort of key issue to keep top of mind is checking in on your legal documentation. So that's not only your privacy policies, but your data transfer agreements and your template customer and vendor agreements. And as we've mentioned, and there's been a common theme throughout this webinar, the world is changing its privacy laws. And so, and essentially, we're all moving towards a point where transparency is king. And when we talk about transparency, it means that we have to find user-friendly and effective ways to provide people with information about how we're processing their data. And it needs to be much more specific and granular than your standard generic privacy notice, which talks more generally about the types of processing you're doing. For example, the CCPA really wants you to map the processing activity to the purpose, and so we need to see things like more creative ways and more specific ways of delivering the information within the privacy policy. And I think related to kind of updating your data processing records, which you talked about, and doing those DPIAs and doing those LIAs, legitimate interest assessments, you should, as an output of doing those exercises, check in to see whether or not your privacy policies need to be updated to reflect new processing activities, new technologies that you've launched that involve new data collections. Make sure that your external facing statements are accurate and up to date, and that you're thinking a little bit more creatively around how that information is delivered. And you almost certainly will need to update your privacy policy to cover the CCPA requirements in addition to all the GDPR requirements. The other thing to think about is, your customer data processing agreements or your customer facing data processing agreements have almost, in many cases, been focused on addressing the GDPR prescriptive Article 28 contracting requirements. The CCPA has got certain requirements around what terms need to be in place with service providers, and so you might want to think about updating, if you haven't already, your existing DPA so that they cover not just the European compliance piece, but they're extended to cover the service provider aspects of the CCPA require you to address in that DPA. And the same will be true of your vendor templates. Make sure that you're covering off those additional service provider requirements in those documents. And, you know, frankly, with the vendor facing ones, you might want to think about just making it a global DPA to reflect, you know, the fact that we know other privacy regimes like the Brazilian data protection law will have similar requirements in the GDPR in terms of what you need to have in place with your vendors. And then back to Brexit again, because I like to end on, we're going to end on Brexit, which seems appropriate. But, you know, just make sure that when you're drafting those template agreements, that when you're referring to things like the EEA, that you might want to revisit those definitions of Europe or EEA, because from the 31st of January, the UK will be outside of the European Economic Area. Now, that won't necessarily hit until the end of this year because we've got this transition period, but you want to make sure that your documentation clearly covers UK data as well as European data. And so, you know, just tweaking some of the references to make sure you're separately and specifically referring to UK data in addition to the European data, because it's basically, you know, the UK will be subject to the UK GDPR, which is effectively going to be the same as the existing GDPR requirements. Now, we might see some divergence over time, but at the end of this year, it's going to be the UK GDPR that will come into effect, and its requirements will be the same as the GDPR at that particular point. Okay, I think we're
running out of time.
Running out of time.
Before we just finish off, there are a couple of questions that I've seen come through. So I will try and group them together so we're not going through all of them, as I know everyone wants to get on with their day. One of them is whether the deck will be available at the end.
Absolutely, yeah. And sorry, this is Charlie, everyone. I think
Sorry.
we introduced her before, but she's our brilliant trainee lawyer who's been doing all the sound monitoring for us, which we're very thankful for.
So yeah, we will try and the slides will be, well, the whole PowerPoint will be available on our YouTube channel, as Flick said at the beginning. But if people need the slides specifically, if you email one of us, we can arrange to have them forwarded to you. Another couple of questions about the DPIA blacklist article that Flick referred to. I will update the follow-up email to make sure the link is in there, so you can all receive a link directly to the article for those who want to read it. Some more specific questions for you both. Someone has asked is.
Oh, okay, yeah. So apologies if you joined a little bit later, but it's the, I'm just going to make sure I say it properly. It's the National Institute of Standards and Technology, NIST. And they basically have come up with this sort of privacy framework. Well, they have a number of privacy frameworks, but you know, famously they've had a cybersecurity framework, and now in January they just published this privacy framework, which is basically a kind of tool that people can use to try and implement things like privacy by design, accountability. It kind of gives people a way to frame their privacy compliance against these kind of NIST standards.
And another sort of final question we have is, have we seen sort of an increase in clients looking to do BCRs? Sort of now it's gone global with sort of privacy compliance. Have we seen more clients look to see whether BCRs are an option?
Yeah, we've had a few clients inquiring about it, but I wouldn't say there's been a massive surge in BCR requests, no more than usual. So I wouldn't say there's been a big uptake in that. The interesting thing about that is I think the BCR applications that are ongoing and are kind of currently being a little bit stalled with the regulators at the moment because they're just overwhelmed with all of the tasks that they have to complete. So I think it's been relatively slow going with some of those BCR applications. But I would expect, and it's a really good question, because I would expect that it's going to become a really useful way to, and it's already the sort of gold standard way of demonstrating compliance or implementing a global privacy approach. So yeah, I wouldn't be surprised if 2020 we see more BCR applications going through, particularly given the challenges to the privacy shield and the model clauses.
Brilliant. I think that's it from questions that we've got time for. So as Flick has said at the beginning, the YouTube channel will have the updated recording for this. We will send out our follow-up email, which will have a link to our YouTube channel, as well as the DPIA blacklist article. On these slides, you can see a link to our blog, and we've also got our podcast, so there'll be sort of more anecdotal updates going through on that. Brilliant. We hope to see you at another one of our webinars in due course.
Yeah, have a lovely day. Thanks very much.
Thank you.